You're on mute, Your Honor.
You would think that a year and a half into the pandemic, I would not be doing that anymore, but you would be wrong. Bear with me for one moment here. All right, so it appears that everyone is present and we are ready to get started. We will begin trial in the case of Marks v. Sonny's Rooftop Bar. My name is Judge Romano. Scoring judges, I think you have already done this, but please look to the two buttons on the lower left-hand portion of your screen. Turn off your audio and video. Those should remain off until the trial ends. You should also have your video set to hide all non-video participants, which means that the only people that should be on the screen right now are the advocates and me. Would the attorneys make appearances, please, starting with plaintiff's counsel?
Good afternoon, Your Honor. My name is Catherine Morris, joined here today by my second chair, Mr. Micah White. Together, we represent Mrs. Ethel Marks on behalf of her deceased daughter, Jessica Marks.
Thank you, Ms. Morris. And appearances from the defense?
Good afternoon, Your Honor, members of the jury. I am Claudio, and I will be the defense counsel in today's trial, along with my second chair, Bridget McNulty.
All right, well, thank you very much. Before we get started with the trial, are there any pretrial matters to discuss?
The plaintiff has a few pretrial matters. May I proceed?
Yes, please.
Under evidentiary ruling 603, we ask for a constructive swearing in of both witnesses.
Yes, all witnesses will be considered sworn.
We would also like to draw to the court's attention evidentiary ruling number 11, which states that exhibits 1, 22, and 23 have been pre-admitted.
Okay, excellent.
Next, evidentiary ruling number 13, which states at all times relevant, Frankfurt Johnson and Sonny Mehta were acting on behalf of the defendant.
Okay.
And next, stipulation 14. And this states that Jessica was born on January 20th, 2000, which at the time made her 19.
Okay.
Additionally, Your Honor, I would like to move to admit exhibit 2 into evidence. This is a picture of Jessica in good faith that I will lay the foundation for it on the direct of Morgan Levin. This just gives me the ability to use this photo on opening statement to give the jury a feeling for what Miss Marks looks like.
Okay, Ms. Claudio, any objection to the photograph being admitted now or being used in opening statement?
Your Honor, I would ask that it's not used in opening statement until it is entered later on in trial.
Okay, do you have a particular argument for why I shouldn't let the jury see it? I mean, the photograph of the one of the people talked about in the case seems fairly uncontroversial.
No, Your Honor.
All right, it can be used in opening statement. And I don't normally admit pieces of evidence before the trial begins. So if you were going to ask for it to be sent back with the jury later, I would ask that you still authenticate it, but there's no problem using it in opening statement.
Thank you, Your Honor. With that, the plaintiff is ready to proceed.
All right, any pretrial matters from the defense, Ms. Claudio?
Yes, Your Honor. We would like to highlight evidentiary ruling number 12 that Stevie Rogers, Gray Grimes, and Frankfurt Johnson are all determined unavailable under Rule 804.
Okay.
And with that, the defense is ready to proceed.
Excellent. Well, in that case, we will now hear opening statements from each party. Everyone should make sure they are in speaker view. That button is at the upper right-hand corner of your screen. And attorneys, please remember to mute your audio when the other attorney is speaking. And with that, plaintiff, you can begin whenever you're ready.
Profit over people. It's March 24th, 2019, around 9 p.m. Two 19-year-olds enter Sonny's Rooftop Bar and present the owner with fake IDs. You'll hear today that these aren't just any fake IDs, but are bad ones at that. They're leaving out their height, their weight, their age, their eye color, and anyone in the restaurant industry should identify these as a fake ID, including the owner of the bar, Sonny Mehta. However, instead of these two 19-year-olds being turned away, they're served drink after drink allowing the bar to bring in more money. One of the friends in less than 3 hours is served 1 beer, 3 White Claws, a shot, and nearly an entire bottle of wine. When she gets up during the night, this friend is stumbling, slurring her words. Her cheeks are flush, her eyes are watery. She's showing signs of intoxication. When the 2 friends leave the bar at 11:45 p.m., the one that was showing those signs does so with her keys in hand. No one at the bar stops her, asks her if she's the one driving, tries to take her keys, tries to order her a cab or an Uber. Rather, they let the 2 friends walk out of the bar. That girl who was showing signs of intoxication, who was holding her keys, her name is Jessica Marks. Jessica Marks attempts to drive home that night and only makes it 1,000 feet before swerving off the road into a ravine and dying on the scene. Today's case is about Sunny's Rooftop Bar valuing profit over this 19-year-old girl's life. And because of that, I'm representing Ethel Marks and suing Sunny's Rooftop Bar for the wrongful death of Jessica Marks. And today, we will prove that Sunny's Rooftop Bar is liable by a preponderance of the evidence. This means that it's more likely than not. And we will do so with 3 key pieces of evidence. First, that Sunny's Rooftop Bar served Jessica regardless of her obvious fake ID. Second, we'll show that Sunny's Rooftop Bar didn't cut Jessica off when she was showing signs of obvious intoxication. And lastly, we'll show that Sunny's Rooftop Bar didn't stop Jessica from driving home that night. Now, we assume that the defense is going to call Sunny Meta to the stand. They're going to testify to you today. And when they do so, they're going to try to deny these allegations. But members of the jury, I'm going to ask you to listen for these key pieces of evidence. Because today you're going to see and hear the ID shown by Miss Marks that she used to gain access to Sunny's Rooftop Bar. You're going to hear Mr. Meta admit that in seconds he can identify it as a fake ID. Next, you're going to see a video of Jessica Marks 40 minutes before the car accident of her showing clear signs of intoxication. And lastly, you'll hear that Jessica at her time of death had a blood alcohol concentration of 0.16, double the legal limit for someone of age, much less a 19-year-old. This evidence will prove that Sunny's Rooftop Bar valued profit over people. And that's why at the end of today's trial, I'll come before you again, and I'll ask that you find Sunny's Rooftop Bar liable.
Oh, Your Honor, you seem to be muted.
Yes, that's probably going to happen. Thank you for bearing with me. Opening statement from the defense.
Yes, Your Honor. May it please the court. The death of a young girl is a tragedy. We agree with the plaintiff today that Jessica Marks' passing is very, very sad. But members of the jury, you will learn today that despite the tragedy, Sunny's Bar is not liable. Because Sunny cannot stop what she cannot see. Now, members of the jury, the plaintiff has to prove that Jessica Marks was served when she was obviously intoxicated. And they have to prove to you today that by serving her, they were a substantial factor in Jessica Marks' death. If they fail to prove to you any one of those facts, you must find Sunny's Bar not liable. Now, for the plaintiff to meet their burden today, they have to prove to you that Jessica Marks displayed symptoms of obvious intoxication to the defendant. It is simply not enough just to prove that Jessica was intoxicated. You will hear that Jessica Marks entered the bar at around 9 p.m. She walked up the stairs, she sat down, and she ordered some drinks with her friend Morgan. Now, members of the jury, Sunny Meta is a trained professional, and she stopped at the bar 8 to 10 times throughout the night. And none of those times did she see Jessica Marks obviously intoxicated. You see, Sunny Meta cannot stop what she just cannot see. Members of the jury, in the police report, you can see on your screen that both Sunny Meta and Frankfurt, the bartender, determined that Jessica Marks had just had a few drinks and that she was fine. Members of the jury, the plaintiff is trying to tell you that by serving her drinks and alcohol, that makes her obviously intoxicated. That because Jessica Marks had some drinks that night and was served drinks, that made Jessica Marks appear obviously drunk. But members of the jury, the plaintiff cannot even determine which drinks Jessica Marks even finished. Morgan Levin said herself in the police report that is displayed in front of you that Jessica had only had 3 drinks. And you will see that later on, Morgan Levin changes her story. And Sunny will tell you that after interacting with Jessica and Morgan 8 times on the night of March 24th, Sunny Meta did not see any signs of Jessica Marks looking obviously drunk. Because Sunny Meta cannot stop, she does not see. Find Sunny's bar not liable. Thank you.
Thank you. All right, we will now proceed to the plaintiff's case in chief. And Ms. Morris, before you call your first witness, I will ask everyone to switch to gallery view. For those who aren't familiar, that button is in the upper right-hand corner of your screen. So now attorneys and witnesses will be able to be seen at the same time. And Ms. Morris, with that, you can proceed.
Thank you, Your Honor. The plaintiff calls Morgan Levin to the stand. Good afternoon. Could you please introduce yourself to the members of the jury?
Of course. Hello, my name is Morgan Levin. I'm 21 years old.
Miss Levin, what do you do for a living?
I'm a full-time student. I go to UCLA. I'm a bio major.
Can you explain how you're connected to today's case?
Of course. Jessica Marks, she was my best friend, and I was with her on the night of the crash, March 24th, 2019.
Your Honor, permission to constructively show Exhibit 2 outside the presence of the jury.
Yes.
Miss Levin, can you explain who this is?
That's Jessica at one of our grad parties.
Is that a fair representation of what Miss Marks looked like?
It is.
Your Honor, the plaintiff moves Exhibit 2 into evidence.
Any objection from the defense?
No, Your Honor.
All right, Exhibit 2 is received.
Permission to publish to the jury?
Yes.
Constructively? Thank you. We can pull that exhibit down now. Were you with Miss Marks on March 24th?
Yes, I was. She was visiting me in California for her spring break.
When did you two meet up that day?
She picked me up from my dorm at around 6 p.m. and we went back to her Airbnb.
What did the two of you do at her Airbnb that night?
We talked, we listened to music, we had a glass of wine.
How old were you two on March 24th, 2019?
19, we had the same birthday. We were birthday twins.
If you were 19, how are the two of you drinking wine?
It was Jessica's idea of an early 21st birthday present, she called it. She got us these fake IDs for Pennsylvania. We were using them the whole week.
I want to focus on Miss Marks' ID. Did you ever see that?
Yeah, I did. I had the same one, just with my face and my name.
Would you recognize it if I were to show it to you today in court?
I would.
Your Honor, now constructively showing what's been previously marked Exhibit 3 into evidence.
Okay.
Miss Levin, can you explain to the jury what this is?
This is Jessica's fake ID, the one she had with her that trip.
Is it true and accurate?
It is.
Has it been changed or altered in any way?
No.
The plaintiff moves to admit Exhibit 3 into evidence.
Any objections from the defense?
No objections, Your Honor.
All right, Exhibit 3 is received.
Permission to constructively publish?
Yes.
Did Miss Marks use this fake ID on March 24th, 2019?
Yeah, that was the one she was using all week.
Where did she use it on March 24th?
We went to Sunny's rooftop bar.
What time did the two of you arrive at Sunny's rooftop bar?
Around 9 p.m., we went there after we hung out at her Airbnb for a bit.
Now I want to talk about what the two of you did once you got there. Where did you go?
We went upstairs to the rooftop part, we got a table, and then we started ordering some drinks.
Do you remember who was taking your orders that night?
Yes, it was Sunny Mehta, the owner.
Did you get a receipt of what you ordered from that night?
I did.
Would you recognize it if I were to show it to you today in court?
I would.
Now constructively showing what's been previously marked as Exhibit 17. Is this that receipt from March 24th?
It is, yeah.
Is it true and accurate?
Yeah, it is.
Has it been changed or altered in any way?
No, it hasn't.
Your Honor, the plaintiff moves to admit Exhibit 17 into evidence.
Any objections from the defense?
No objections, Your Honor.
All right, Exhibit 17 is received.
Miss Levin, I see that it says your name on the bottom. Did you drink everything on this receipt?
Oh, no. Jessica and I got all of our drinks on one tab. It was easier than splitting it.
What on this receipt did you drink then?
The Decoy Red Blend, it was a bottle of wine we split, and I had a glass. I had one of the IPAs, one of the green tea shots, and we split the chips and guac.
Did Miss Marks drink the rest of what was on this receipt?
She did.
Was there anything that Miss Marks specifically drank on March 24th that isn't marked on this receipt?
She had a Captain and Coke, or a Coke and rum. She got it for free from one of the bartenders, I think.
Do you know which bartender?
Sorry, I believe that there was an objection. Go ahead, counsel.
I'm objecting to hearsay in the statement that she got it from one of the bartenders that night. She heard that from Jessica Marks. This is
Respond?
inadequate.
May I be heard, Your Honor?
Yes.
There's no specific statement I'm referring to. Therefore, there's no statement going to the truth of the matter asserted. This is simply her knowledge of the night of March 24th, 2019.
Your Honor, may I respond?
You may.
In order for Ms. Morgan Levin to testify to the fact that she was provided this drink, she has to imply hearsay because Jessica Marks told her that she got the drink for free from Frankfurt. Therefore, that is an out-of-court statement being used for the truth of the matter asserted.
May I be heard on that, Your Honor?
You may.
Under 801, for something to qualify as hearsay, it must be going to the truth of the matter asserted. The fact that she got it for free is not going to the truth of the matter asserted. What we're saying is that Jessica drank a rum and Coke, and that rum and Coke is not on today's receipt.
Okay, so I'm going to sustain the objection for now. I think the problem really is that we haven't heard any foundation from the witness about how she knows that Jessica Marks drank that drink. So it's kind of a different question whether she saw it or whether she heard the bartender say it, right? So lay that foundation, and then depending on the nature of the foundation, you can seek to offer that testimony again about the drink that is not included on the receipt.
Yes, Your Honor.
Miss Levin, were you with Miss Marks all of March 24th, 2019 while at Sunny's?
I was with her almost the entire time.
Did you ever see her drink something that wasn't on this receipt?
I did. She drank some sort of Coke and rum drink, but I didn't pay for it.
Thank you. We can take down this exhibit now, Mr. White. I want to talk about Jessica's behavior specifically. How would you describe her behavior throughout the night on March 24th, 2019?
She started out relatively fine, but as the night went on, she just got drunker and drunker.
Why do you say Miss Marks got drunker and drunker? Can you describe the behavior she was displaying?
Yeah, her eyes, they were red and watery. She was slurring her words, and she was stumbling a bit.
Did she ever stumble in front of you?
She did, yeah.
From what you know, did anyone else see Miss Marks stumble that night?
Yeah, she actually stumbled right into Sunny when we were coming down from the rooftop one time.
Did Sunny say anything when he saw Miss Marks stumble?
Yeah, Sunny kind of caught Jessica, set her straight, and said to Frank we may need to cut this one off.
At that point, did Mr. Mehta cut Miss Marks off?
No, she didn't.
Prior to today's trial, were you shown Exhibit 10, the video of Miss Marks on March 24th?
I was.
How are you familiar with that exhibit?
I took the video.
Would you recognize it if I were to show it to you today in court?
I would.
Your Honor, now displaying what's been previously marked as Exhibit 10. Do you recognize this?
That's Jessica. That's the video I took.
Does it look true and accurate?
It does.
Your Honor, the plaintiff moves to admit Exhibit 10 into evidence.
Any objections?
Yes, Your Honor. We object to hearsay. This video contains out-of-court statements.
And please.
Your Honor, under Evidence Rule 801 D2B, this is admissible because this is a declarant unavailable due to death.
Your Honor, although we agree that this is a declarant unavailable due to death, this does not mean that this is not still hearsay, an out-of-court statement.
Okay, so if you agree that this is a situation in which the declarant is unavailable due to death, why does this nonetheless remain hearsay?
Your Honor, because this has to prove intent or motive or something of that character for an unavailable declarant who is dead to testify.
Okay, your response, plaintiff?
Your Honor, this evidence rule allows testimony of a declarant if they are unavailable. Miss Marks is unavailable, and furthermore, it allows this evidence to be admitted into evidence because what she's saying and doing shows the behavior and how she could have looked intoxicated to a clear person, Your Honor.
Your Honor, may I respond?
Yes.
So, according to this rule, this has to show the intent and motive of the bar, which this video does not show for this to be an exception to hearsay.
Mm-hmm. So I think on the subject of the declarant unavailable rules, it's not quite so neat, I think, as the plaintiff is arguing. There has to be a reason why the declarant is unavailable, which one of them is that the person has died, and then also some other thing. And I think that's what the defense is alluding to. There's an unavailability plus a reason why the testimony or the statement nonetheless should come in. I am curious, though, about your argument about it displaying her physical characteristics. Can you speak some more to that particular argument?
Yes, Your Honor. It's not her words that are being used to the truth of the matter asserted, but rather her behavior and her actions that can be used to display her intoxication.
Okay. And defense counsel, do you have a response to that particular argument?
Yes, Your Honor. They're using the way she says her words and what she says to try and prove their point today for obviously intoxication. And therefore, it is being used for the truth of the matter asserted, not allowed under Rule 801.
Okay. I don't think that those sorts of things, a person's affect and the way that they communicate really counts as hearsay here, given the purpose for which the plaintiff's offering it. So I'm going to overrule the objection.
Yes, Your Honor.
So the document or the exhibit will be admitted.
Mr. White, can you please just start this video? Doesn't appear that we can hear it. May we stop the clock while we figure that out?
Yes, that's fine.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
That the defense second chair called time. Plaintiff second chair, where do you have us on time?
It also appears that we are out of time.
Okay, that'll conclude the direct examination then. Thank you. Cross-examination?
Yes, Your Honor. Now, I would like to talk to you about the events that happened following the accident. Now, Jessica's mom blamed you for the death of her daughter, correct?
She did. I was with her that night. She thought I don't know, should have done more. I don't know.
She threatened to sue you, correct?
She did.
And you were under the belief that Miss Marks is no longer going to sue you.
I haven't heard about it again, so I don't think she is.
But before you gave the deposition, you were with Miss Marks's lawyers.
That's correct. She was the one who asked if I would give the deposition, and I wanted to do whatever I could for Jessica, so I did. I spoke with them beforehand.
But you are testifying today for Miss Ethel Marks, who threatened to sue you.
I'm testifying for Jessica. Ethel's her mom, yeah.
Now, let's talk about the day of March 24th. Now, Miss Levin, you saw Jessica Marks in her Airbnb, correct?
I did. We got there at about 6:30 from my dorm.
And you are unaware of what she drank earlier that day.
Yeah, I don't know if she drank anything at all.
So if she had been drinking, you wouldn't have noticed by the way she was acting.
I didn't notice anything. I didn't see her earlier, and I didn't notice that she had been.
So to you, she seems sober, correct?
That's correct.
And I would like to talk to you about how much you remember from the night of March 24th. Now, Miss Levin, you were at the bar with Jessica Marks, correct?
Yes, that's correct.
And you and Miss Marks ordered drinks together, correct?
We did. We were both on one tab.
Now, you remember that you ordered wine first,
Yes, we did.
but you can't remember what you ordered after that.
No, I don't remember the specific order. We started with the wine and we ended with the shots. I don't remember the order of the rest.
And you do not remember which drinks Jessica Marks finished.
No, I don't know how much she finished of them.
Well, I would like to show you Exhibit 23, which has already been entered into evidence. Now, one second. Now, oh, one moment, I apologize. Now, you told the police that you should have stopped her.
Objection, Your Honor. A lack of foundation. May I be heard?
You may.
Although this exhibit has already been admitted into evidence, I asked that opposing counsel lay the foundation as to what this exhibit is to this witness.
That's fair. So I think it isn't proper to use this exhibit with this witness in the way that you're doing it. I think we either need foundation about the exhibit from her, or you need to ask her about the statements made to police, and if she then disputes the statements or doesn't recall them in the same way as they're characterized here, then that may change your ability to use this report.
Yes, Your Honor. I ask that my screen share stop screen sharing this exhibit at this time. Now, Ms. Levin, you spoke to the police, correct?
I did. They spoke with me that night.
Yes, and you spoke right after Jessica Marks had died.
Yeah, we did.
And you told them about what she drank, correct?
I did. I told them we'd been drinking.
I now ask for my co-counsel to screen share Exhibit 23. Now, you told the police that
Your
you should-
Honor, I once again object to the use of this attorney's use of this exhibit, as they're trying to impeach this witness through these statements rather than just asking her questions.
Your Honor, may I respond?
Yes.
We have laid the foundation that these are statements made by Morgan Levin, and we are using this exhibit not to impeach her, but to show that she changes her story before and after the deposition.
You are using this to show that she made statements to the police before the deposition that are different from the things that she said in the deposition. Do I understand that right?
Yes, Your Honor. Yes.
Okay. You still haven't laid any foundation for if she knows this document, and nor have you asked her about the statements. So I think it is still improper at this time to show her and have her read statements off the police report. But you can get there either if perhaps she recognizes this, or if you need to confront her about the things that she says. But you need to start in one of those two places.
Yes, Your Honor. I asked my screen share to stop screen sharing exhibit 23. Now, you told the police that Jessica had a few drinks.
Yeah, I told them we'd been drinking that night.
And you told the police that Miss Marks had only had 3 drinks.
Yeah, I said, I don't know, maybe 3. I was in shock. Her car had just crashed. I wasn't counting.
Miss Levin, that's a yes to my question. You told the police, the figure who asked you right after she died, that she had only had 3 drinks, correct?
Yeah, I said a few, maybe 3. I didn't know.
Now, you didn't tell the police that Jessica Marks was very drunk that night.
No, they didn't ask. They asked if she'd been drinking, and I told them she had.
But you didn't tell the police that she stumbled before she left the bar.
No, they didn't ask. They just asked if she'd been drinking and if I knew where she'd been.
Well, on the night of March 24th, you drank alcohol too, correct?
I did.
Now, you claimed to be that you weren't drunk.
No, I wasn't drunk. I'd had a glass of wine, a beer, and a shot. I was a bit buzzed, but I wasn't drunk.
Now, are you familiar with Stevie Ridgers?
No, I'm not.
You are not familiar with Stevie Ridgers, who was at the bar with you that night?
No, I don't believe so.
Well, I'm showing you Exhibit 23, and Your Honor, I move to enter Exhibit 23 into evidence. The court ruled pre-trial that Ridgers was unavailable, and this deposition is taken from a case where he was subject to examination by both sides and is admissible testimony. And under Stipulation 21, this exhibit has already been determined fair and accurate.
Okay. Plaintiff, any objections to the admission of Stevie Ridgers' deposition?
Yes, lack of personal knowledge under this witness says just testified that they don't know who this person is.
Your Honor, may I respond?
You bet.
This witness does not need to have personal knowledge of Stevie Ridgers. We are asking her about the contents of this and how this is different from how she believes the night was spent.
Right. I don't think that she was trying to offer this as something that the witness had personal knowledge about. It sounds like, and Ms. Claudio, correct me if I'm wrong, that you were trying to impeach the witness with information that a different witness said. Is that fair?
Yes, Your Honor.
And so the basis for the foundation, I think, is not anything that the witness knows, but is those other things, the stipulation, the pretrial ruling, et cetera. So other than the ground that you raised, do you have any objections to the admission of this deposition?
No, Your Honor.
All right. It'll be received. If you nonetheless think there is something objectionable about the manner in which this deposition is being used with respect to the witness, please feel free to renew your objection.
Now, I'd ask you to divert your attention to page 7, and I'd like you to focus on lines 12 through 13. Now, Mr. Ridgers said that you were wobbling.
It says her friend was wobbling. I don't know who her is or who he's talking about.
Well, as you can see, he was referring to Jessica Marks' friend. Were you Jessica Marks' friend that night? You were Jessica Marks' friends that night?
Yeah, Jessica was my best friend. I was with her that night.
And you were wobbling that night?
I don't think so, but Apparently, this guy does.
Now, Mr. Rogers stated that you were in worse shape than Jessica, correct?
Yeah, he said that.
My co-counsel can now stop screen sharing Exhibit 26. Now, you had drinks that night, so you did not feel safe to drive.
No, I didn't. I called an Uber and I tried to get Jessica to go with me.
Now, you called an Uber because you had drinks that night and also to try and warn Jessica.
Yes, I tried to get Jessica to come with me, but she didn't.
Now, you felt the need to call an Uber, even though you had less drinks than Jessica?
Yeah, I didn't want to get in the car with Jessica because she'd had a lot more drinks than me. I didn't think she should be driving.
Yes, but you had enough drinks that night to believe that you had to take the Uber.
Objection, Your Honor, asked and answered.
I'm going to overrule that.
Your Honor, no further questions.
Okay, thank you.
May my witness be excused, Your Honor?
Yes, she meant it. Thank you very much.
And at this time, the plaintiff rests.
All right. I think given that this is a relatively short trial, that we can probably just proceed straight to the defense case unless either party needs a break at this point.
The defense is ready to proceed.
Okay, and I take it there's no further evidence from the plaintiff?
No, Your Honor, the plaintiff rests.
Defense, you can call your witness then.
The defense calls Sunny Mehta to the stand. Can you please introduce yourself to the jury?
Good afternoon. My name is Sunny Mehta. I used to run Sunny's Rooftop Bar in Malibu.
And how did you come to run the bar?
Well, I started off as a waitress, and I always dreamed of one day owning my own place. So I worked my way up, and I started Sunny's back in 2017. It was an amazing place. Prime real estate right over the Pacific. It was really a dream come true.
And what were your responsibilities when you ran Sunny's Bar?
Well, I had to make sure that I was never serving customers who were obviously intoxicated. And in terms of what I was doing at the bar, I was serving drinks, taking orders, and at some points I was also making drinks as well.
And did you have any safety precautions in place?
We did. Like I just mentioned, I'm aware that I can't serve obviously intoxicated customers, and so I'm always monitoring my customers for the symptoms of intoxication that they might be exhibiting.
And if someone was intoxicated, what steps would you have to take?
I would cut them off. That's the law.
Now, Ms. Mehta, I would like to talk to you about your bar. Would you recognize a picture of your bar?
I would.
I asked Ms. McNulty to screen share Exhibit 8. Now, do you recognize this picture?
Yes, I do.
And is this a fair and accurate depiction?
It is, yes.
I now move to enter Exhibit 8 into evidence.
No objections, Your Honor.
All right, Exhibit 8 is admitted.
Now, Ms. Mehta, where is your bar located?
My bar is in Malibu.
And can you describe the layout of your bar?
Sure. There are 2 floors, an upstairs patio and a downstairs as well. The bar is downstairs. That's where we make all the drinks. And then the patio is upstairs. That's where most of our customers sat.
Now, Ms. Mehta, I would like to ask you about March 24th. Can you explain what your bar looked like that day?
Sure. It was a Sunday night. It was relatively quiet. We had maybe about 20 people in the bar, 12 or 14 on the patio at a time.
And did you see Miss Marks or Miss Jessica or Miss Levin at your bar that night?
Yeah, I did. They came in around 9.
And can you show me which table they sat in?
They were at table 4. It's the table on the right there. It's cut off in this photo, but it has the blue cushions.
My co-counsel can now stop screen sharing Exhibit 8. Now, did you come over to their table?
I did. I was taking their orders that evening, and I was bringing them their drinks as well.
And what did they order that night?
They ordered a bottle of wine, a couple of beers, a couple of seltzers, and some shots.
And did Jessica order all the drinks?
No, they were sitting at the table together and they were both ordering those drinks.
And at any time, did Miss Marks seem intoxicated?
No, I didn't see her exhibit any of the signs that I'm trained to look for.
You said you're trained to look for signs of obvious intoxication. What signs would imply that she was intoxicated?
Well, there's really a spectrum of intoxication. Some of the signs that I look for to indicate that someone is obviously intoxicated are a loss of judgment, loss of balance, loss of hand-eye coordination, passing out, throwing up, anything like that.
And did Jessica display any of those symptoms?
Not that I saw, no.
And during the night, did Morgan ever seem intoxicated?
She didn't seem obviously intoxicated. She did seem like she might be a little bit tipsy, though.
And what symptoms did she display?
Well, at one point, I remember she was signing the receipt and she had trouble holding the pen. She signed it really slowly.
And was there any time of the night that Jessica seemed drunk to you?
No, not at all.
I'm now screen sharing exhibit, or would you recognize a video of Jessica Marks in your bar?
I would.
I'm now asking my co-counsel to screen share exhibit 10, and it's already been entered into evidence. Can you play the video, please? One moment.
It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Now, you stated you never saw Jessica Marks obviously intoxicated. Can you explain to me why this is not obviously intoxicated?
Well, Miss Marks isn't exhibiting any of those symptoms of intoxication that we just talked about. She's not slurring her words. I don't see that she had a loss of balance or anything like that. And so I don't believe she's obviously intoxicated in this video.
Even if she was, did you ever see her like this at any point at night?
No, I didn't. I mean, I never saw this video recorded. I didn't see this video on the night. I never saw her acting like this.
Thank you, Ms. Maida. No further questions, Your Honor.
Ross.
Yes.
Now, Miss Meta, you own Sunny's Rooftop Bar, right?
I did. I owned it for about 2 years.
And you were working at your bar on March 24th, 2019, right?
That's right.
That night, you personally checked every ID by hand, didn't you?
That's right, I did.
That meant before anyone could get alcohol, they had to go through you. Isn't that true?
That's right.
Now showing what's been previously admitted as Exhibit 3. According to this is Jessica's ID, correct?
It looks like, according to this, that this is Jessica's ID. I don't remember seeing this ID on the 24th, though.
I'm not asking you about March 24th, but this says that this is Jessica's ID, right?
It does say that, yes.
And to you, this is clearly fake, isn't it?
It is. There are no holograms. It doesn't list her eye color or height and weight.
And it doesn't even say her gender, does it?
That's right.
Now, on March 24th, you were Miss Marks' server, weren't you?
I was.
You served her drinks containing alcohol.
Her and Morgan Levin, that's true. They were sitting together.
I want to focus right now solely on Miss Marks. You served Miss Marks multiple drinks that night.
That's right.
You believe you ID'd her.
That's true. I ID'd every customer that came into the bar, but I don't have a specific memory of seeing her ID. I mean, I see IDs every day. I don't remember this one.
However, you're aware now that this is the only ID Miss Marks had as she was only 19 years old.
I'm not sure if this is the only ID she had. I'm sorry.
So we can take that exhibit down now. Now, it's your policy to ID anyone under 45,
That's right.
but you don't remember IDing Miss Marks.
I don't remember seeing that ID.
Whether or not Miss Marks ID'd or Miss Maida ID'd or didn't ID Mrs. Marks throughout the night is not relevant. It's not disputed that that Sunny's bar served a minor. That's not the prevalent issue in this case today.
Your Honor may be heard.
Yes, please.
This is just showing the liability that Sunny's bar neglected multiple things that night. They served a minor. They don't know if they ID'd her, and then they served her past when she was drunk. That's what the defense is arguing.
Your Honor,
That's what the plaintiff is arguing.
may I respond, Your Honor?
Yes.
And furthermore, I would object improper character evidence because they're using the fact that she didn't ID her to say that they served her later on that night, obviously intoxicated. And one action therefore validates a different action.
I don't think that's improper character evidence. I'm going to overrule the objection.
Yes, Your Honor.
So you don't remember IDing her, right?
I don't remember seeing that ID, no.
Now I want to talk about your experience working as a bartender. As a bartender, you received training on how to identify signs of intoxication, right?
That's right. I'm certified with the state of California.
One of these signs is not making sense.
That's true. That's a possible symptom.
Loss of balance,
That's another possible symptom, yes.
slurred speech,
Another thing that I look for in my customers, yes.
talking loudly.
That's true.
Now you were shown Exhibit 10 on direct examination, correct?
I was.
And you stated that she wasn't obviously intoxicated in that video, right?
Not from what I could observe, no.
You said that because she didn't display a loss of balance, right?
But not a loss of balance or slurred speech or any of those symptoms, no.
But however, Miss Marks at the end reached for the wrong drink, didn't she?
I'm not sure. I'm not sure whether she meant to reach for another drink.
But this could display confusion in Miss Marks.
That's possible, but I didn't think it was enough to conclude she was obviously intoxicated.
Miss Marks talked about being famous on Hollywood.
I think she did, yes.
And you would say that that's her making sense?
Objection, Your Honor. They're using that statement for the truth of the matter asserted, which is not admitted under hearsay rule 801.
Thoughts?
Your Honor, this witness stated that they don't believe this was a sign of obviously intoxication because she wasn't slurring her speech. Therefore, I'm allowed to contradict that testimony by showing the speech she wasn't slurring didn't make sense.
Your Honor.
They opened the door on direct examination.
Ms.
Mayor-
Claudia, yes. You
Mayor
can respond. Nick.
We spoke about the slurred speech, but they're bringing up a statement about Hollywood and then saying that that is confusion. Therefore, they are using that statement for the truth of the matter asserted. And when they entered this exhibit, they said they were not using it for the truth of the matter asserted.
I don't think they are still. I mean, you're right that their admission of this was premised on that it would not be offered for the truth. I don't think either side is arguing that Miss Marks was Hollywood famous. I don't take that to be the plaintiff's argument. So I think it is being offered for a non-truth purpose still. And so the objection is overruled.
Yes, Your Honor.
Furthermore, you claim that you didn't see this video taken.
That's right, I didn't.
And you believe that Miss Marks never acted like that when you served her, right?
No, absolutely not.
Let's move on. Now, you're aware now in your deposition of Miss Marks' BAC after her death, right?
I'm aware of that now, yes.
And now you know that Miss Marks' BAC was 0.16, correct?
I am aware of that, yes.
You as a bartender know that the legal limit for someone of age is 0.08.
That's true.
And you now know that Miss Marks was not 21.
I know that now, yes.
At no point on March 24th, 2019, did you ever cut Miss Marks off, did you?
No. Frankly, based on her behavior, I didn't think it was necessary.
Thank you, Your Honor. No further questions at this time.
Thank you. Is there any redirect examination?
Yes, Your Honor, briefly.
Okay.
Now, what behavior made you believe that Jessica Marks was not obviously intoxicated?
She just wasn't exhibiting any of the symptoms of intoxication in front of me. I interacted with her maybe 8 or 10 times that night, and I never saw her exhibit any of those symptoms.
Thank you, Ms. Maida. No further questions, Your Honor.
All right. Thank you. Do the parties need a break at all before closing argument? Oh, and Ms. Maida is excused, of course. Are the parties prepared for closing argument, or do you all need a break beforehand?
The plaintiff can proceed in closing argument unless a juror or spectator needs a break.
The defense is ready to proceed as well.
All right. We'll just go ahead with closing arguments then. Everyone should please switch back to speaker view. And since both witnesses have completed their testimony, then you can complete the witness portions of the ballot.
Your Honor, before I proceed, I would like to confirm that any time I have remaining on closing argument may be used for rebuttal.
That's fine.
May I proceed?
You may.
Profit over people. Members of the jury, you heard today that that is what Sunny Mehta did to Jessica Marks on March 24th, 2019. They viewed her as a profit rather than a person. And it's because of that that we're suing the defendant for the wrongful death of Jessica Marks. Now, today I have the burden of proof. And I have to prove by preponderance of the evidence that Sunny's Rooftop Bar is at fault for Jessica Marks' death. Your Honor, I've met that burden. Members of the jury, I did that with 3 key pieces of evidence. First, that Jessica Marks was served regardless of an obvious fake ID. That Jessica continued to be served despite showing signs of intoxication. And that no one attempted to stop Jessica from driving home. Together, these 3 things prove that Jessica died as a result of Sunny's Rooftop Bar. Because Sunny's Rooftop Bar valued profit over people. Let's take a look at these each one at a time. First, Jessica's fake ID. We heard Sunny testify today on this exhibit. We heard them admit that it was a fake ID. She said that there was no height, no eye color, no hologram. She knew within seconds that this was a fake ID. Miss Mehta told you that she was IDing everyone that looked under 45 in the bar that night. Members of the jury, let's look at Jessica. She doesn't look 45. She doesn't look 35. She doesn't even look 25. So either Sunny Mehta did not ID Miss Marks or that she didn't care that the ID was fake. Because rather than seeing Miss Marks as a person, on March 24th, Sunny's Rooftop Bar saw her as profit. Second, Miss Marks continued to be served despite showing signs of obvious intoxication. Today, we prove that Miss Marks' blood alcohol level was double the legal limit. It was at a 0.16. Members of the jury, that's double the legal limit for someone who is 21, much less a minor. Miss Mehta came on the stand today and said that she didn't believe Miss Marks was showing signs of intoxication. Members of the jury, a minor had double the legal limit. A clear person could have understood that she was showing signs of intoxication. And remember, it's not just that Miss Mehta had to believe that she was showing signs of intoxication. It's just a reasonable person. Because remember that video, Exhibit 10 we saw. 40 minutes before Jessica passed away, she was talking loudly. She wasn't exactly making sense. She had a loss of hand-eye coordination. You also heard testimony of Morgan Levin. Miss Levin told you that Jessica Marks stumbled down a flight of stairs, displaying her lack of balance and coordination. To find Miss Meta liable, you must ask yourself, would Mr. Meta and Sunny's Rooftop Bar know the signs of intoxication? Well, when I asked Miss Meta to describe that behavior of an individual who is intoxicated, you heard her say that it's talking loudly, not making sense, a loss of hand-eye coordination, and a loss of balance. Miss Meta told you when those signs are displayed, the person is obviously intoxicated and needs to be cut off. Yet Sunny's Rooftop Bar never cut Miss Marks off. They continued to serve her drink after drink. You heard testimony that Jessica stumbled out of the bar with her keys in hand, and no one at Sunny's stopped her. No one asked if Miss Marks was driving. No one at Sunny's asked if Miss Marks needed a ride home. No one at Sunny's took the key from an obviously intoxicated individual. Profit over people. Together, these facts prove that Sunny's bar was serving Jessica, and there was a substantial factor in her death. We've met our burden. But we anticipate that the defense will come up here and say that we haven't met that. So let's walk through the requirements of the jury instructions that you need to believe to find Sunny's Rooftop Bar liable. Today, we prove that Jessica was 19 years old on March 24th, 2019 through the testimony of Morgan Levin. We prove that Jessica was obviously intoxicated both through the testimony of Morgan, Sunny, and Exhibit 10, as well as her blood alcohol concentration. And through all these things, we have proven that it is more likely than not that Sunny's negligent behaviors of serving a minor was a substantial factor in Miss Marks' death. Her death was caused by driving under the influence. Sunny's Rooftop Bar put profit over the life of Jessica Marks. Hold them responsible. Find Sunny's Rooftop Bar liable.
Thank you. Closing argument from the defense.
Yes, Your Honor. Now today, the plaintiff does have the duty to prove, and they have the duty to prove that Sunny's bar served an obviously intoxicated minor that displayed symptoms to the employees of Sunny's bar. And by serving Jessica Marks that alcohol, that was a substantial factor in her death. Now, Your Honor, they failed to prove, or members of the jury, they failed to prove causation today. They failed to prove that it was a substantial factor. Now, they were required to prove that by serving Jessica Marks that alcohol, she died. Now, they failed to connect the alcohol to the actions. They failed to connect that serving that alcohol was a subsequent action that caused her death. Furthermore, they have not proved that Jessica Marks showed signs of obvious intoxication to the defendant on March 24th. Now, Sunny Meda is trained to identify people who are obviously intoxicated. Now, she told you she never saw Jessica Marks exhibiting those signs of intoxication. They tried to show to you a video and say that that was obvious intoxication. But Sunny Meda told us today that obvious intoxication means very drunk. She explained to us that because she had slurred words, which Sunny denies, by the way, that because she was struggling to pick her drink, that she was drunk. Now, that does not mean obvious intoxication, members of the jury. Stevie Rogers, a reasonable person, showed us a few things today. Now, Stevie Rogers' deposition shows us that Jessica Marks was not obviously intoxicated. He said that he laughed a lot. She said that she was obnoxious. But laughing and obnoxious is not obvious intoxication. Laughing and obnoxious does not make Jessica Marks obviously drunk. Stevie Rogers, also what he didn't say, tells us a lot. He tells us that Jessica Marks never fell and never stumbled. And Stevie did not see that she was obviously drunk. Now, members of the jury, Frankfurt, another person who was working at the bar, also did not see that Jessica Marks was obviously intoxicated. Now, the police report will show you, and that you will have access to in the following trial, will say that he only saw Jessica Marks have a few drinks and that she was only a little tipsy. Members of the jury, tipsy does not mean obviously drunk. And if Jessica Marks was only tipsy, then Sonny cannot cut her off. Sonny cannot stop her from drinking if she doesn't see her acting obviously drunk. Now, Morgan Levin told us today that Jessica was obviously intoxicated and that whole night she was drunk. But Morgan Levin also had a few drinks that night. So much so that Stevie told us Morgan could not even walk straight. And Sonny told us that Morgan looked worse off than Jessica. Stevie Rogers, Frankfurt, and Sonny Meadow have all displayed and showed you that Jessica Marks was not obviously drunk throughout that night. Now, in order for the plaintiff to meet their burden today, they have to prove to you that Jessica Marks was obviously drunk in front of them. And they have not met that burden. They have to prove to you that by Sonny's bar serving alcohol to Jessica Marks, that is why she died. And they have not proved that to you. Members of the jury, Sonny Mehta is a bartender. Sonny Mehta owned Sonny's bar. And she was there all throughout that night. And she never saw those symptoms. We cannot put Sonny Mehta at fault for something she didn't see. Sonny Mehta could not stop Jessica Marks' death because she saw nothing. Find Sonny Mehta not liable. Thank you.
Thank you. Rebuttal argument from the plaintiff?
Yes, Your Honor. Profit over people. Members of the jury, opposing counsel just said Sonny can't stop what she can't see. But really, the evidence showed that Sonny chose not to see, not to stop, to get more profit. Remember the facts we heard today. How much Jessica drank at Sonny's rooftop bar. A beer, a shot, 3 White Claws, and nearly an entire bottle of wine. At 10 p.m., she stumbled down the stairs. At 11 p.m., we saw how she was acting by Exhibit 10. And remember, it's not what Sonny believed was obvious intoxication. It's that a clear-minded person would believe she was intoxicated. And then at 11:45, 40 minutes after that video was taken, she makes it 1,000 feet before swerving off the road, driving off the ravine, and dying. With a blood alcohol concentration of 0.16. Members of the jury, if she wasn't overserved, if she wasn't obviously intoxicated, Jessica would still be here today. Sonny's rooftop bar valued profit over people. Find them liable.
All right, thank you very much. That concludes our trial. I'm going to turn off my camera and finish up my ballot and give the other judges time to do that. Judges, if you can just message in the chat when you're done with your ballots. Thank you.